Hi everyone, this is Dave Stauss. I'm a partner with Husch Blackwell's Privacy and Cybersecurity Practice. Thank you for joining us today for this on-demand webinar. Today we are providing a summary of Texas's first privacy law enforcement action. With me today is Marlaina Pinto, an attorney in our Privacy and Cybersecurity Practice group. The QR codes that you see on this screen will take you to our LinkedIn profiles. We publish a lot of privacy content on LinkedIn, so feel free to friend or follow to stay updated. If you attended a prior webinar, you know that we like to provide a roadmap for our webinars. That way you know what to expect. Today's webinar is broken into 4 parts. First, Marlaina will provide the background facts of the case. Next, I'll talk about the violations Texas has alleged, and then Marlaina will go through what the potential damages are for those violations. Finally, we'll identify some takeaways. Before we start, I want to be clear that these are just allegations. The defendants are entitled to respond, and none of the allegations have been proven to a trier of fact. Okay, I'll turn it over to Marlaina now to go over the factual allegations.
Thanks, Dave. Hi everyone, I'm Marlaina Pinto, and as Dave said, I will walk through a factual summary of the case. On January 13th, the Texas Attorney General's office filed a complaint against the Allstate Corporation and its subsidiary Arity. The complaint first alleges that the defendants created a software development kit, or an SDK. An SDK usually consists of a set of tools that developers can use to build applications and operates in the background of the app. The complaint further alleges that the defendants paid third parties millions of dollars to incentivize them to use the defendant's SDK in order to collect consumer location and movement data. The defendants allegedly chose to partner with apps that already contained features that relied on location information to function correctly so that they could collect user data under the pretext of providing a necessary function. Second, the complaint states that once the SDK was integrated into an app, a user was unknowingly agreeing to the defendant's collection of their location information. The information collected included a mobile phone's geolocation data, trip attributes, including things like start and end location and trip duration, GPS points, derived events such as acceleration, speeding, and distracted driving, and metadata. The defendants have collected data from over 45 million Americans, including allegedly millions of Texans. According to the Attorney General, they did so without providing notice or obtaining consent. After collecting the data, the defendants allegedly monetized it in 2 ways. First, they used it to support their own car insurance business. And second, they built what they advertise as the world's largest driving behavior database and sold access to it to third parties, including other car insurance carriers. The complaint alleges that insurers use the consumer data to justify increasing consumers' car insurance premiums, denying them coverage, or dropping them from coverage. As I touched on earlier, the complaint alleges that neither the defendants nor the apps the defendant's SDK was integrated into informed the users that their data was being collected, used, or sold by the defendants. According to the Attorney General, the defendant's privacy policy actually says they do not sell personal information for monetary value. And they do not provide a way for consumers to request that the defendants stop selling the consumer's data. Now that we've laid out the facts, I will turn it back over to Dave, who will go through the alleged violations.
Thanks, Marlaina. So in total, Texas alleges 5 violations of the state's new privacy law, as well as violations of the state's new data broker law and existing insurance law. It's worth noting that Texas's data privacy law went into effect on July 1st of 2024, so this enforcement was very quick. Okay, so let's talk about the first violation. For each of these 5 violations, we'll provide you with the specific text of the privacy law that was allegedly violated, and then a short description of what the alleged violation was. So here, Texas alleges that the Arity defendants were a controller and that they failed to provide a privacy notice that disclosed what sensitive personal data they were collecting. For the second violation, Texas alleges that consumers were unaware of the Arity defendants and did not consent to their collection of precise geolocation data. Texas claims that this violated this section here, 541.101b4. Texas also said that the mobile applications collecting consent for their collection of precise geolocation data was not enough to cover Arity's collection. It's a reminder that consent must be specific and informed. For reference, this is Texas's definition of sensitive data. The complaint focuses specifically on precise geolocation. Now, keep in mind that other states require consent to collect sensitive data. Utah and Iowa require notice and a right to opt out, and Maryland stands alone right now, requiring that the collection be strictly necessary to provide the product or service requested by the consumer. So there is variation in the states, whereas Texas requires consent. There are other states that are different. And California itself has its own regime. Also, keep in mind that the definitions of sensitive data change across states. Some states' definitions of sensitive data are broader than Texas's definition of sensitive data that you see here. Moving on, for violation 3, Texas alleges that the Arity defendants were selling data when they transferred it to third parties. As such, they were required to provide this disclosure that you see here on this page, which is posting on their on their website, rather, we may sell your personal data. This language is unique to Texas. I believe it also appears in Florida, but that has a much narrower scope with respect to the types of companies that it applies to. Here, for violation 4, Texas alleges that the Arity defendants sold personal data and let businesses target consumers based on those sales, but the defendants did not provide an opt-out mechanism or a clear disclosure as required by this section here, 541.103. Violation 5 involves two parts of the privacy law. First, Texas alleges that Arity did not provide a privacy notice to consumers and, by extension, did not include a notice of how to opt out to consumers. And that allegedly violated this section here, 541.102A3. In the second part of violation 5, Texas alleges that even if a consumer navigated to Arity's website, there was not an adequate method for consumers to exercise their opt-out rights. Among other things, Texas noted that to opt out of targeted advertising, Arity directed consumers to a third-party website instead of providing a way to exercise the request, such as through a consent management platform. Finally, the complaint alleges that the Arity defendants did not register as a data broker under Texas's data broker registration law, which went into effect in 2024. And the complaint alleges that all the defendants violated the Texas Insurance Code. Okay, now let me turn it back over to Marlaina, who's going to go through the alleged damages.
Thanks, Dave. So overall, Texas claims more than $1 million in monetary relief and seeks various forms of non-monetary relief. As far as monetary relief, Texas requests a civil penalty of not more than $7,500 per violation of the Texas Data Privacy and Security Act. Pursuant to the data broker law, the state requests a civil penalty of up to $10,000. This amount includes two requests. First, an amount of not more than $100 per day the defendants were in violation of either the registration requirement or the notice requirement. And second, the amount of unpaid registration fees for each year the defendants failed to register as a data broker. And pursuant to the state's insurance code, Texas requests up to $10,000 per violation. In addition to monetary relief, Texas seeks an injunction and requests defendants delete or otherwise destroy all data obtained, including any data in the possession of any third party. The state also requests the defendants make full restitution or restoration to all consumers who suffered a loss as a result of the alleged acts. Now I will hand it back over to Dave to wrap up with some takeaways.
Thanks, Marlaina. Now let's go through some takeaways from this complaint. The first takeaway is fairly obvious. If you are collecting sensitive data, you need consumer consent. So you need to understand what data elements are considered to be sensitive data. You also need to obtain consent properly. By that I mean consent needs to be informed, which means you need to disclose why you are collecting the data and what you are going to do with it. Consent also needs to be specific. You can't bundle consent. In other words, you need to tell people specifically what you are collecting and have them consent to that specific collection. For sensitive data, that is. You can't have them consent to an entire privacy policy. There's also a challenge here in this case because the SDK is being called a controller, but it doesn't have direct access to consumers. It goes through the third-party apps. We see that on occasion. We don't know what the agreement said here, obviously, and we don't want to speculate, but if you are in that situation where you are relying on another party to obtain consent on your behalf, then you need to make sure that it's happening, and you should also address it contractually. The second takeaway is also fairly obvious. Your privacy policy should be complete and accurate. Regulators will read the statements and judge those statements against your processing activities. Third is perhaps less obvious, and that's the need to make sure you have data processing agreements in place and that they comply with law. Here the complaint specifically references the defendant's agreements with app developers. That means the Attorney General's office is obtaining and looking at those contracts. Finally, regulators aren't going to stop at just one issue. They will look at everything. Here the complaint alleges issues with how the defendants managed their opt-outs, including their targeted opt-outs. That had nothing to do with what they were doing with sensitive data, but it's in the complaint and it's a violation. I want to thank you for attending today's on-demand webinar. Before you go, I did want to highlight that we are running a service right now tracking AI bills at the state level. It is a paid monthly paid service. You receive a weekly newsletter with the status of proposed state AI bills. We are tracking well over 100 bills to date. You can use the QR code to find that site and more information. Also, if you're interested, we run a blog, Bite Back Law. The QR code will take you to Bite Back where you can find subscription information there. That is free. For our normal blog is free, whereas our Bite Back AI service is paid. Thank you for attending today's on-demand webinar. We'll be talking to you soon.